The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Thank you, Mr. Shima. And I'd like to start by welcoming counsel, as well as those who are watching on our Supreme Court Live channel. We appreciate counsel for facilitating the switch to Zoom on a fairly late notice. So thank you for that, your cooperation. At this time, I would ask Mr. Doug Shima, the clerk of the appellate courts, to please call the first case on our 9 a.m. docket.
Thank you, Your Honor. May it please the court. The docket for Wednesday, May 18th, 2022 consists of two cases. First case to be heard on the docket is appeal number 123599 in the interest of N.E., a minor child. Reno County briefs both sides. The second case immediately following will be appeal number 123156, City of Olathe versus the City of Spring Hill, Kansas. Johnson County briefs both sides. Your Honor, the appellant, in the interest of N.E., has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Travis Turnus on behalf of the appellant IE.
Mitchell Engel on behalf of the appellant IE.
Jennifer Harper for the state of Kansas.
Thank you. Mr. Engel, you may begin your argument.
Thank you. May it please the court. My name is Mitch Engel and I represent the appellant. We will refer to by her initials IE for the sake of privacy. This is a child in need of care case where a grandma wanted custody of her granddaughter. Unfortunately, her case ended up in front of a district court judge that has a personal belief that in such situations, custody of these children should be given to foster parents over family like grandparents. And the district court judge disregarded Kansas law to reach the result that she wanted. Now, in our brief, we've outlined many of the legal errors committed by the district court, but I want to just focus on two right here. The first is that the district court ignored the familial preference doctrine and the substantial consideration that should be given to grandparents. There are many Kansas statutes, the DCF handbook, and the United States Code that lay out the principle that families should be preferred in such situations. I just want to highlight two of them to start. If you look at KSA 382270B, it says that when determining custody, the first priority should be to keep the children with their family. And then if you look at KSA 382286A, it says that when making these custody determinations, substantial consideration should be afforded to grandparents. Unfortunately, the district court knows that this is the law, but disregarded it here. It referred to these doctrines as ill-advised and unproven theories. And then it added a level of review so that DCF could not make kinship placements without first having her approval. The second major legal error committed by the district court was that it did not engage in the statutorily required best interest analysis. It said that it was basing its rule on its experience as an adoptive mother. It said it was basing its ruling on assumptions. So I think it's helpful to look at, this is the June 11th, 2020 order regarding placement. It's volume 2 of the record on appeal starting at page 39. Now for context, the court entered this order before it had heard any evidence about either the fitness of the grandma or the foster parents to raise this child. And here's what—
I'm sorry for interrupting, but I would kind of like to address the elephant in the room, which is whether or not we have jurisdiction over this case. So what you have is a prior Supreme Court case that says that any post, the dispositional phase of a sync case ends when the district court terminates parental rights. And, in order for us to hear this case, we would, since it's precedent and given stare decisis, we would have to find that that was an error. So give me your best argument of why the dispositional phase of a sink case ends when the district court terminates parental rights.
Thank you, Your Honor. So I think that there are three reasons why we respectfully believe that NAC should be reconsidered here. So as we all know, jurisdiction is a creature of statute. So we should look at what the statute says about when the Court of Appeals has jurisdiction. The statute here is KSA 382273. And subsection A of that says, an appeal may be taken by any party or interested party from any order of temporary custody, adjudication, disposition, finding of unfitness, or termination of parental rights. So there's basically two questions we have to ask. Is the grandma a party or interested party? That question's easy and undisputed. The statute says that grandparents are interested parties. And the second question is whether the orders that we are, I'm sorry.
I think that was just feedback. I don't know what that
Oh, I'm sorry. So the second question then is whether the orders that we are appealing fit into one of those five categories. Now, this court said that in NAC that decisions, custody dispositional decisions after the termination of parental rights cannot be appealed. But respectfully, if we just look at the plain language of the statute, there's nothing to give that sort of indication. It says that any adjudication order can be appealed. So this court, one of the reasons it said was that the legislature has an interest in timely deciding these child in need of care cases to give permanency to these things. Now, respectively, the legislature could have done that in the statute. It could have limited the time that you can appeal disposition orders to only orders entered before the termination of parental rights, but it did not. It took a different approach to make sure that these appeals were timely heard. It entered a different statute that says appeals in child in need of care cases take priority over all other appeals. That's KSA 382273D. The second reason is if you look at the structure of the code, there's no reason to believe that the dispositional phase ends at the termination of parental rights. So there's a couple of key statutes here discussing dispositional orders. If you look at KSA 382253, this just says after a child is adjudicated a child in need of care, the first dispositional order has to be entered within 30 days. And then you look at KSA 382256, and this says after the entry of any dispositional order, the court may rehear the matter on its own motion or the motion of a party or interested party. And then it says after that rehearing, the court may enter any dispositional order authorized by this code. Now, we believe that there were at least two dispositional orders entered here. The first is the order denying my client, the grandma's motion for custody of her child. Now, the Court of Appeals said that this order could not be appealed because it likened it to a motion for a change in placement. So
what date are you talking about, this motion for custody, the court's order?
So that's not entirely clear, Your Honor, because as this June 11th order kind of explains why the district court was not going to grant custody, but then it said we're going to have some hearings on it to enter further evidence. And then after that,
the June 11th order really just a documentation of the April 30th where the court was denying placement, not custody, because the motion for interested party status and the motion for change in custody by grandma was filed on May 22nd. And it seemed to me that the June 11th order went back to specifically talk about the April 30th denial of placement, right?
I think that's a fair reading. And if you look at the subsequent orders, it's not entirely clear when grandma's motion for custody is denied, but it had to have been denied at some point. This case is done at the district court. So
well, counsel, that was denied in December, right? After a 2-day evidentiary hearing that happened over actually a couple of different months. But that motion for a change in custody was filed after the initial order in April by email on the placement question. Then custody was litigated after that, and ultimately a ruling was made in December. That's my understanding from the record. Is that incorrect or correct?
That's another fair reading. Again, if you look at, so you're referring to the December 22nd order. It's called a journal entry of permanency hearing for child in need of care post-termination. And so I believe if you look at paragraph 10 of that, it says the previous orders of this court are hereby rescinded and the following orders are hereby issued pursuant to KSA 382255. And so if you look at what is KSA 382255, that's the statute that sets up what sort of disposition orders are allowed. So if there's no mention in here that the district court is specifically denying grandma's motion for custody, but if this is the order that denies it, that is a dispositional custody order.
Mr. Engel, will you just repeat, the journal entry talks about permanency what? I mean, what's the title? Journal entry?
Journal entry of permanency hearing for child in need of care post-termination.
Okay, thanks.
And then if you keep looking at under paragraph 10, it says the court further orders, quote, custody of this child shall be terminated with DCF and the child shall be placed in the custody of the foster parents. So this is an order determining where the custody is. So Justice Wall, you're correct. This might be the order in which the district court was kind of sub silento denying grandma's motion for custody, although it's not entirely clear. There's no
The December 22nd, 2020 order specifically mentions 38-2255.
Correct. It says the previous orders of this court are hereby rescinded and the following orders are hereby issued pursuant to KSA 382255.
Okay, thanks.
So we believe that this is a post-termination of parental rights disposition order. I think where this court in NAC went wrong is it invented, or it did not invent, it used a new term, permanency order, to refer to disposition orders that happened after the termination of parental rights. But this term permanency order, it doesn't appear anywhere in the child in need of care statutes. So there's no reason to believe the legislature would have included it in the type of orders that can be appealed.
Counsel, is there any significance to the fact that grandma's motion for custody was filed before the state's petition to terminate parental rights, but then the petition to terminate was heard before grandma's motion for custody because of a continuance? Is there any significance to that chain of events? In other words, the motion filed first was not heard first. The motion filed second was heard first. Anything to that, or is that just a red herring?
Well, I agree. I think there's practical significance to this. I think we'd all agree that if this disposition order was entered before the termination of parental rights, we wouldn't have the NAC jurisdictional problem, and it would be clear error. You can't disregard Kansas law. You can't just call statutes ill-advised and unproven theories. The problem now is that if that order was only denied after the termination of parental rights, under NAC, grandma would never have a chance to have this reviewed. Your Honors, I see I'm out of time, so I'll reserve the rest for rebuttal unless there are further questions.
If I may, Chief.
Yeah.
Let's assume we stand by our precedent and we don't depart from that. You also appeal from the termination order, and the Court of Appeals said that your client lacks standing to appeal the termination order because only parents have standing. What is your response to that? What is your challenge to, what is your substantive challenge to that termination order? And what gives the grandmother standing to challenge that?
Yes, Your Honor. So this goes to when the parental rights were terminated, the district court gave custody to DCF, but the district court placed limitations on DCF so that it could not make kinship placements, could not make custody decisions to grant to grandma without the district court's approval. And we believe that this should be decided without these handcuffs on DCF.
But that termination order did not reference those limitations.
That's correct, but they had already been in place prior.
Right, those were established, if I recall, and correct me if I'm wrong, in the temporary custody order in the case.
That's correct. That June 11th order we were talking about.
And you did not challenge that order on appeal.
Well, we are challenging that to the extent we can. I think the Court of Appeal said that that's not a final order.
But, the grandma was granted interested party status, correct?
Correct. The district court said that grandparents are interested parties.
So in the case, grandma's an interested party in the case.
That's
Correct?
correct, Your Honor.
And I guess the question is the designation of, by statute, of being an interested party, does that satisfy both the statutory and common law standing requirements for our case in controversy jurisdictional requirement?
And Your Honor, we believe it does. Specifically, going back to the jurisdictional statute here, it says that an appeal may be taken by any interested party from any order termination of parental rights. So by the jurisdictional statute, it's clear. And we've discussed the harm that came about by putting those handcuffs on DCF instead of allowing it to just do its normal process here.
What's that statute number again?
The jurisdictional statute is KSA 382273. And subsection A is what I've been quoting from.
So an interested party has the right to.
Yep, that just says when an appeal may be taken.
Other questions? Thank you, counsel.
Thank you so
Ms.
much.
Harper?
Thank you, Your Honor. So first, I would just like to clarify a few things that have been previously stated. It's stated that they're trying to appeal the termination order. However, when you look at it, they're not appealing the termination. They're not appealing the finding of unfitness. They're appealing DCF custody when DCF custody is exactly what they're asking for. And the termination order that he says throws handcuffs on them is actually an August 19 order, which is not one of the orders that they're attempting to appeal. And when they initially filed an appeal, they just said they were filing dispositional order appeals. They never filed a notice of appeal for any termination or finding of unfitness appeals. And Justice Sandridge had a question regarding permanency journal entries referring to the dispositional statute. Permanency journal entries are mandatory forms under Supreme Court Rule 174A2.
Permanency what are mandatory?
Those journal entries.
Okay. But a permanency order, as far as before NAC has, when they're talking about what can be appealed, a permanency order, is that mentioned anywhere else in the sync code?
Well, I'll touch on that right now. If you look at the permanency statute, the only place in that statute that mentions dispositional orders is, I believe it is subsection H.
What's the statute?
Okay, statute number. Sorry, I have it written down. 38, 22, 64, subsection H.
Okay, and what does that say?
It starts with, when the court finds that reintegration continues to be a viable alternative, that's when it talks about dispositional orders. However, when you go down to subsection J, it states, if the court determines that reasonable efforts of progress have not been made towards reintegration, then the court may rescind its prior orders and make other orders regarding custody. And if you look at other orders post-termination, disposition is never mentioned.
Let's talk about that a little bit. So NAC, the Supreme Court decision says the dispositional phase of a sync case ends when the district court terminates parental rights. What in the sync code supports this legal conclusion?
I think a big part of that is if you look at the authorized disposition statute itself, none of those authorized disposition statutes apply to post-termination.
But neither do they exclude post-termination. And in fact, I guess what I don't understand is disposition is custody, right? Would you agree with that?
Not really. Disposition is custody.
Yeah, go ahead. I'm sorry.
Disposition is essentially case plan and custody.
Okay, but let's talk about the custody part of it, because that's what NAC is saying, the disposition. Would you say that there's only one dispositional order allowed in a sync case?
Not necessarily.
Okay, so custody, I mean, the statutes clearly provide that a trial court can reevaluate its prior decision about custody / disposition, even on its own motion, correct?
Yes.
Okay, so where is this distinction coming from that there can be a disposition that's reviewable before termination of parental rights, but not afterwards? What in the law makes that distinction?
Well, I think it again goes back to the authorized dispositions. The last authorized disposition is if reintegration is no longer viable. There's nothing that really talks about post-termination dispositions.
Well, 2270 talks about post-termination custody, right? 2270. I mean, it talks about when parental rights have been terminated and it appears that adoption is a viable option, the court shall enter one of the following orders. An order granting custody of the child to DCF or to the proposed adoptive parents. And then subsection B right there says, in making an order under subsection A, the court shall give preference to the extent it's in the best interest of the child to grant custody to the relative, or actually even someone who the child has close emotional ties to. Why isn't that a disposition? What in the code says, you know what? Those disposition orders for custody are not appealable. But if that would have happened, like in this case, as Justice Wilson pointed out, if the judge had heard the motions in the order that they were filed, the motion for custody was filed by grandma before the motion for TPR. But what ended up happening here so let's say that the judge said, okay, I'm going to hear the TPR, I'm going to hear the motion for custody first, and then denied custody to grandma. Okay, then that would be appealable. Would you agree? Under NAC?
If the motion was heard and ruled upon pre-termination?
Yes.
Well, I think part of that comes to whether or not it actually was a dispositional motion that she was filing.
But is it custody disposition? I don't understand your distinction.
With me, we need to look at the purpose of disposition. It's not just custody.
What else is it?
It's custody and plan. Because when you look at authorized disposition, it talks about the custody and what the plan is.
But you can't appeal a plan. So can you never appeal a custody decision because it includes planning? Because then what you're saying is under the disposition statute, which, you know, the permanent one, not the temporary, but the I guess, semi-permanent because it can be changed at any time. Then you're saying that that isn't even appealable because it includes a plan?
I'm not sure why you couldn't appeal like the planning stage of a case.
Okay, so let's move on. So any decision, regardless of whether, so any decision after TPR is basically unreviewable by this court. Is that your position? Any decision by the district court. So, if the district court judge picked a friend of hers that had never even met the children, the kids had been in a foster home, or let's say that the kids had been with grandma. And then there was a termination of parental rights and DCF was going forward. And the district judge said, you know what, my friend really wants a baby. So I am going to take custody from DCF and give custody for adoption to my friends who want a baby. We couldn't review that under NAC, right?
Well, that's right, but there are other steps that could be taken.
Okay, I just wanted to make sure you were right there. Also, 2270 talks about that the specifically says that if the state is not making progress towards adoption, then that is when the court can come in. Let's see. That is when the court can come in and say, I'm going to take custody away from DCF, because really DCF is one that after termination, DCF is, that's what the legislature intended, right? DCF makes these decisions. That's why you have these meetings. If there's two competing foster parents that want them, then DCF usually makes that decision, right?
Yes, and they were in support of the foster parents.
Right, but I'm just saying, the legislature intended DCF to make these decisions. In this case, DCF recommended the child go to the grandma, right?
No.
Well, okay. So I found some emails where it said that, but okay, but let's take that
I
aside.
can clarify that if you'd like.
I'm sorry? No, that's okay. Because my question is more legal in nature. No, now I lost my train of thought. If the DCF usually makes that decision, but what evidence is there in this case that the state had not made adequate progress towards adoption?
Well, a big part of it is that essentially they had just been continually dragging their feet. The court had been waiting for them to make progress, and they just hadn't been doing anything. They had been stalling and stalling. I mean, grandma's started.
Would you read that on March 25th when the child was 5 months old? Well, no, had been in foster care for 5 months. So the child was 9 months old. At DCF did an assessment of grandma.
She started an assessment.
All that was left, and because it was COVID, it was by video. So all that was left really for DCF to do was go in and actually look at the place. And then there was like a gate, or, there were 2 or 3 small things. And otherwise she would have passed.
No, there was quite a bit more for her to complete. In fact, by the December hearing, her assessment still had not been completed.
Right, but what had not
So
been
from March until December, they still hadn't completed an assessment on the grandmother.
what needed to be done?
They were still waiting on paperwork.
What paperwork?
They had to have another interview with her. They wanted to do another walkthrough of the house, I believe.
Well, they needed to do a physical walkthrough of the house because the other one was virtual because of COVID. What else?
They were waiting on various paperwork.
What paperwork?
I'm sorry, Justice, I don't remember right off the top of my head.
Could I ask you what I had asked your opposing counsel? If you have a statutory right to appeal, does that mean that you've satisfied a case in controversy requirement? Or is there an additional showing that's required for jurisdiction here? And I guess my question specific to the termination order, what rights are implicated that give rise to a case or controversy for a grandparent when a termination order is entered?
You see, that's one of the ones I've had issues with because, again, she's not appealing anything.
In the termination order?
That's correct. She flat out said she's not appealing the rights being terminated, she's not appealing the unfitness, and she's not appealing DCF custody. And quite frankly, at the October hearing, DCF wanted the child to remain in contact with the foster parents. St. Francis said they wanted the child to remain with the foster parents. And now that we're a year and a half into it, I can't imagine them placing the child with the grandmother at this point.
Counsel, I'd like to pursue perhaps a slightly different line of questions that I think stem from the same concern that at least I hear animating Justice Standridge's questions, which are essentially a concern that there could be district court orders of such importance that are just effectively completely unreviewable. So I'd like to start with the statute at issue here, which is 38-2202M. You would agree, right? The statute within the code granting appellate jurisdiction.
Okay, yes.
And actually, I may have said that wrong. I think it's 2202M is the interested party statute. 2273A is the sort of 5 category statute. Is that, I got that right? Okay, good. My reading of NAC is that the court essentially read a sort of a sequential pattern into 2273A and said that these categories of appeal follow the sequential pattern set out by the legislature for the resolution of these cases. Is that right?
Yes, that's my understanding.
And so NAC basically said that, look, once you reach the end of the sequence, and the end of the sequence comes with termination of rights, that you are now no longer within the orbit of 2273A. So you can't get appellate jurisdiction through 2273A once you reach the end of this sequential process. Is that right?
Yes.
Okay, so if that's right, and if the holding of NAC we're going to follow, it's clear here that because these orders came after termination of rights, they cannot fall within the orbit of 2273A. That's the state's position, right?
Yes, Your Honor.
Okay, now this is my question. That was all lead up to my question, which is, I don't know that any parties or this court have ever considered whether 60-2101 steps in to fill the void. If you don't have appellate jurisdiction under 2273A, because we're at the end of the sequential pattern, why doesn't 2101, which is just the broad general appellate jurisdiction for over any district court order by the Court of Appeals, why doesn't that kick in to give appellate jurisdiction over orders that aren't covered by 2273A?
Well, I will say that I have not looked at that statute in preparation for this case, but I'd have to say it's probably because sync statutes are, well, they're self-contained, or the sync code is pretty specific, and I just worry that if we say that, then it will kind of open the door to, if anything isn't within that 5 category, then people are going to want to go to that.
How would we discern that that's what the legislature wanted? I mean, it strikes me that appellate jurisdiction is the rule and a lack of jurisdiction would be the exception. And so unless the legislature were to expressly say that there shall be no right of appeal for any order post-termination, why would we sort of assume that from the statute? In other words, I can see the logic of NAC saying, look, this particular statute is only governing rights of appeal up to termination. That actually makes sense to me. And the Kansas Supreme Court have a subsequent case, I think it's In Re TS, which sort of applies NAC and says, look, you can't, and that case dealt with an attempted appeal of a denial of parental termination. And this court said, NAC controls, and whenever you're in this process prior to termination, you've got to fit one of these 5 buckets, and a denial of termination doesn't fit one of the buckets.
Mm-hmm.
But this situation seems different to me, which is where we're sort of outside the orbit, where we've already gone to termination. So 2273A just doesn't apply. But I guess, again, the question is aimed at asking what's the state's position on why does that end the matter? Why can't we look to other statutes to find appellate jurisdiction?
Which, again, I would just say the sync code is within itself. I don't think we should really be reaching out to other statutes.
Thank you.
In regard to wanting to, Chief, can I continue that a bit?
You may.
In regard to not wanting the legislator not wanting cases to continue out, I would just point out how long this appeal process has taken. We were in the district court for 16 months, and even with this case being expedited, no extensions being granted, and us getting before this court in just about 2 months, we've still been in this appeal process for another 16 months. This child's only 37 months old. So with us needing to look at cases in child time and getting process done quickly, that's a lot of time that's been taken of this child's life just through the appeal process. And I think that's something that really needs to be taken into consideration.
Are there other questions of Ms. Harper? Ms. Harper, we basically gave you no time for argument, so I will give you just a few seconds if you just want to wrap up and state what you would like the court to do.
Thank you, Your Honors, for hearing us today.
Mr. Engel, I'm sorry.
Oh, I'm sorry.
I maybe couldn't be heard. I was just giving Ms. Harper a chance to wrap up since we had taken so much of her time and questions. If she'd just like a few seconds to tell the court what she would like for us to do.
Thank you, Chief Justice. I would just ask that you follow NAC and find that there is no jurisdiction here. If nothing else, just look at the relief that they're requesting. They're requesting that the child be placed into DCF custody. And as I stated previously, back in October of 2020, DCF stated that they were not recommending placement with the grandmother. St. Francis stated child would be traumatized to be removed from their foster parents. Those foster parents have since adopted the child, so that child is now their actual child. And there's been about over 16 months since that time. A child would just be so traumatized to be removed from the parents and placed into DCF custody, and I honestly can't imagine DCF doing anything except allowing the foster parents to readopt the child. Meanwhile, the grandmother's only had a couple of days with the child. So I would just ask that you continue to find NAC to be good law and find that there's no jurisdiction.
Thank you, Ms. Parker. Mr. Engel, you may now proceed. I think you reserved 3 minutes for rebuttal.
Yes, Your Honors. 2 quick points I want to make. The state keeps referring to the sync code as being self-contained and saying that what should be appealed is what she kept calling authorized dispositions. So if you look at KSA 382255, that is where it says authorized dispositions. And then you look at the December 22nd, 2020 order. Court says it's entering an order pursuant to KSA 382255. It's hard to see how that order is not a dispositional order. It specifically says custody of this child shall be terminated with DCF and the child shall be placed in the custody of the foster parents. Second point I want to make is the importance of this case. Now, the state may be right that if DCF gets this case back and determines that it's in the best interest to stay with the foster parents, that very may well happen. And that's a decision that DCF should be making, not an appellate court, respectfully. But here's the problem, is that if we don't allow this process to play out, cases like this are just going to keep happening. This court knew the law and consciously disregarded Kansas law. I just want to read briefly from the June 11th, 2020 order, starting on page 3. Here's what the court said. And remember, this is before it had heard any evidence about the foster parents, had heard no evidence about grandma. It said, quote, "It would never be in a child's best interest to be placed with a disabled family member if the alternative is a young, healthy family." Next paragraph, quote, "Of course, I do not have those facts to compare, but in making an assumption, because in my experience, families involved in the pipeline of foster to adopt infant children are normally younger, healthy, 2-parent households. It just can't be that an interested party, grandma, who's supposed to get substantial consideration in this custody, has no ability to ever challenge these type of rulings based on no evidence. That's why we're respectfully requesting that this court hold it as jurisdiction over this case, vacate the foster parents' adoption, reverse the district court, and remand so that the Kansas DCF can determine proper placement in custody without restrictions on being able to make kinship placements. Thank you.
So can I ask you really quickly about your remedy, which is to unwind the adoption in another proceeding? Explain to me what authority our court would have to do that here in a separate proceeding that's already run its course, I guess.
Well, Your Honor, they are related proceedings, and once this court has jurisdiction, it can correct any errors made by the district court. And if you look at the Court of Appeals decision in Ray NAC, the Court of Appeals, they're held that it did have jurisdiction and authority to do that, and that holding was never questioned at the Supreme Court in NAC.
Well, we didn't need to get to that issue, right, in light of the jurisdictional question.
That's correct, Your Honor.
If it's an error of law in this case, doesn't that necessarily void the adoption proceedings without us having to order that?
I think that's correct, Your Honor. So if there are no more questions, thank you, everybody, for your time.
Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. Thank you, counsel. At this time, we'll have a transition in our proceedings while the attorneys in this case leave the hearing and the attorneys for the other case are brought in for our next matter. Mr. Sheila, would you please call the next case on the morning docket?
Thank you, Your Honor. The second case for the 9 a.m. docket is appeal number 123156. Excuse me, 124156. City of Olathe, Kansas versus the City of Spring Hill, Kansas, and James Hendershot, City Administrator for the City of Spring Hill, Kansas. Johnson County briefs both sides. Your Honor, the appellant, City of Olathe, has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Sheila. Counsel, would you please enter your appearances?
Your Honor, Tony Rupp appears for the City of Olathe. I would like to recognize, if we were live in court, I would have here with me Ron Shaver and Chris Grunewald, the City Attorney and Assistant City Attorney, and Matt Stromberg and Sarah Stula, who were with me on the briefs.
Thank you.
And Your Honor, this is Kurt Tiedemann for the City of Spring Hill and James Hendershot.
Thank you, counsel. Mr. Rupp, you may begin your argument.
Madam Chief Justice, may it please the court. This case involves the enforcement of an annexation contract setting forth the growth areas for the City of Olathe and the City of Spring Hill. It was approved in 2006 by the city councils of each of the cities, executed appropriately by each city, and incorporated into each city's statutorily mandated comprehensive plans and the City of Spring Hill's annexation policy. Each city abided by it for 15 years until in March of 2021, when the City of Spring Hill announced it was going to annex north of the contractually agreed boundary line so that it could be involved in a project dubbed Project Extract. There is no question that the Spring Hill project breaches the annexation contract. The question is whether the contract is enforceable under the Kansas Supreme Court's decision last year in Jayhawk Racing. The purpose of this contract was to designate and delineate a boundary to avoid annexation disputes, encourage planning, construction of public improvements, and the provision of municipal services in the areas affected. It prevents premature annexations and gives property owners certainty about future land use and services. This case presents an important question. Faced with the need for long-term planning for streets, roads, water and sewer, and in the face of a history of controversial and expensive annexation wars between cities, particularly as Johnson County has grown, may two cities contractually agree to define their future growth areas. The City of Olathe agrees with the district court that this contract serves the public interest, and we agree with the district court that the contract is authorized by KSA 122908.
Can we start right there with the authority under 122908? And really that gets back to just the general authority pursuant to statute under the interlocal agreement that starts with 12290801. The district court found that this was a service agreement between Olathe and Spring Hill. Can you describe to me what services are provided by this interlocal agreement? It just, and to cut to the chase, it just seems to me this is an agreement for an interlocal agreement for pertaining to annexation. It's not a service agreement that contemplates some services to be provided. It's a contract or an agreement not to do something. And why does 2908 apply under those circumstances?
Thank you, Your Honor. It's an excellent question. 122908 authorizes municipalities to contract with each other, quotes, to perform any governmental service, activity, or undertaking. So I think
hit that. What is the activity or undertaking that's done here? It's to not do something. And it even involves a service contract to property they have not an interest in. I'm having trouble here getting beyond that point.
Well, I do believe that they do have an interest in, because it does define the future growth areas of each city. For example, the statute authorizing comprehensive plans authorizes cities to deal with their future growth areas. And I would submit that nothing could be more of a governmental undertaking than long-term planning for orderly growth and development to guide planning commissions, city government when evaluating development applications, rezoning and land use policy decisions. Those are, as the court is well aware, annexation, long-term growth, where you put your water, your sewer, your roads, your street, your interstate exchanges, all of which, by the way, are at issue here, because there is a long-term build-out plan for each city that analyzes exactly when roads, streets, water, sewer will be developed in each of the growth areas. So these two cities have undertaken the governmental service and activity of planning being an activity of the government, planning out when roads, sewers, et cetera, will be built under build out plans in each of these communities. And that's those are expensive propositions that include long-term planning. And that's the purpose of agreement, in conjunction with the fact that obviously there had been annexation wars in Johnson County, and this truce that was entered into, and these types of contracts are entered into between a large number of cities in Johnson County and their neighbors. I think this type of government planning and orderly growth and development is exactly the type of governmental activity or undertaking that the statute authorizes. And these terms.
And why isn't 2904 more specific to what you just described?
2904
isn't that the purpose of 2904 is just, and it just seems to me that is what the parties contemplated here, is entering into an interlocal agreement not to annex pursuant to 2904. And it just seems to me that if 2904 doesn't apply, why does it even exist?
2904 deals with a broader category. It allows municipalities to enter into other types of governmental relationships with Native American tribes, with counties, state, with others, whereas 2908 pertains to contracts between municipalities. 2908, really, if you look at the legislative history of it, is very separate from 2904 in that it eliminates the burden on the Attorney General of having to approve every agreement between municipalities to get to an interlocal agreement between Olathe and Spring Hill, for example, or between Olathe and Overland Park.
It's interesting if you look at the other interlocal agreements that your client has entered into with other municipalities, a number of them did seek Attorney General approval, and they're very similarly structured. So I would assume in that scenario, the Olathe was complying with 2904 and not worried about 2908 because they sought Attorney General approval. Here you didn't. So and remarkably similar interlocal agreements. What's the difference?
I would agree that they are similar interlocal agreements. I don't have the dates in front of me exactly, but 2908 came about after 2904. It came about so that the Attorney General didn't have to approve all of these. I think that the parties could have written this under 2904. They chose to write it under 2908. Not both sides were represented by competent counsel. Neither side felt the need to submit this to the Attorney General because they believed that this was covered under 2908, and we have the benefit here of an evidentiary hearing before Judge Mason, and Judge Mason heard the evidence that included the testimony of the former city attorney as to of Olathe as to the intent that this would be under 2908. The court made that factual finding based on her read of the contract and also her hearing of the evidence in the case. And there really was no contrary evidence as to the intent of the parties here. The language, as you know, between 2904 and 2908 is largely similar, and there are a couple of distinctions, but for the most part, the language is similar.
Counsel, can I jump in and kind of ask a conceptual question? In my experience, which I think is probably pretty representative, questions of municipal growth are very often some of the most hotly contested political questions in municipal elections. And so the question is, would the law that you're advocating for essentially permit the citizenry of a municipality to resolve that political question and then bind their children and their children's children? In other words, why can't, let's say 25 years ago, I live in Lawrence, my parents' generation said, we want to resolve this growth question for all time. And so we're going to enter into all these contracts. And now 25 years later or 50 years later, why couldn't a subsequent generation on a political question just say, we don't agree with that anymore? We're gonna resolve the growth question a different way.
Thank you, Your Honor. That's a good question, and I would submit two things. Number one, the perpetual nature, the argument as to whether this is a perpetual agreement and whether it is binding 15 or 20 or 25 years from now, as set forth by Spring Hill in its brief, is not the issue that is here. And if you look at page 12 of their brief, they say, and I'm reading it right now, that Spring Hill has never claimed that all perpetual contracts between municipalities are automatically void for that reason alone. And Spring Hill's position in this case, adopted by the district court, is merely that Jayhawk Racing does not permit one governing body to bind the next on a governmental matter.
That's not answering really the question. I mean, I guess I'm not certain that my question is completely in line with Spring Hill's position, but I'm still interested in an answer.
Your Honor, I think courts always have an ability to reform a contract at some point in time on issues as to what I would consider your question, which touches on the perpetual nature of this. I think the question is whether it can go for a duration that is beyond the next city council.
Right. Well, and if election. Doesn't that undermine principles of democratic rule?
I don't think,
fundamental question.
I don't think it does. Annexation questions remain. The question of a specific annexation still falls obviously within the purview of a city council. This is the type of long-term planning that I think is that is authorized by 122908. I wouldn't disagree with you that annexation and land use issues are political, but we do believe that this statute authorizes this contract. If it were under 122904, that provision does the parties to set forth a duration in the contract. We think this could have been authorized under 122904. The parties chose to authorize it under 122908, which does not require a specific duration. But we do think on the question that's pertinent to this case, whether it can, whether the duration can be beyond the term of the next city council, the answer is yes. I don't think that's delving into a prohibited area.
Other questions? Thank you, Mr. Rutt. Mr. Tiedemann?
Yes, Your Honor. May it please the court. I'm going to argue 2 points today. The first one being that the district court properly dismissed Olathe's petition because the annexation agreement is not binding on the current city council under the Jayhawk Racing decision. The second issue, which is my cross appeal issue, is that irrespective of Jayhawk Racing, this agreement would be invalid anyway as an interlocal agreement without Attorney General approval under 12-2908. The first issue is that the annexation is not enforceable under this court's Jayhawk Racing decision. The annexation agreement was entered in 2006. Since 2006, Spring Hill has elected and seated several new city council members. In fact, there's only one holdover from that time. So there's no question that by trying to enforce this agreement on the current city council, that it is attempting to bind future city councils. In 2006, there was even at that time a question about whether or not the contract would be binding on future city councils. That's in the court's judgment, Record on Appeal, Volume 3, page 99. And frankly, the Jayhawk Racing rule and cases on it are not entirely new law. It's merely the latest case on that set of issues. And so even at the time, Olathe attorney Tom Glinstra testified that he knew that the whole idea of an interlocal agreement for annexation purposes was a novel concept. He further admitted that everybody who entered such agreements did so knowing that it may or may not be valid. Move the clock ahead for 15 years, and a new city council in the city of Spring Hill evaluates the various benefits and detriments of this annexation agreement differently than the 2006 city council. And that under Jayhawk Racing, the 2021 city council of Spring Hill was entitled to do. Is there any, I'm curious or concerned about the impact this may have statewide in terms of all the interlocal agreements. And I don't know the volume of that or how the number of that were entered into between various communities. But would your argument that Jayhawk Racing applies to all of those? In other words, a city or enters into an interlocal agreement with an adjacent city similar to one here, and then a new city council is voted in 2 years later and doesn't want to comply with that agreement or feels like it wants to alter the direction. And maybe it was a hotly contested thing, as Justice Stiegel just said. The community didn't want to enter into that agreement and elected a new city body. Is that how that would work in your mind, that they could just within a year or two just not abide by that agreement?
It's hard for me to envision every single agreement which might be entered into, but I will say this. I do think that to the extent one city council is under the agreement, claims to be entitled to bind the next, then yes, I think Jayhawk Racing would prohibit the binding nature of that agreement. Now, there are probably different ways that you could enter into that agreement. You could make it, perhaps you could make it so that it could be canceled by one governing body or the other, or perhaps it could be renewed. But I think quite clearly, if it's a perpetual agreement like this one, where there's no way out and it's irrevocable, I think that's going to be a problem under Jayhawk Racing.
Yeah, and let me just ask you, and maybe this blends in a little bit to the second issue that you have with 2904. But let's just alter it a little bit and say this was done under 2904. Attorney General's approval was sought and granted. Is that then binding on a subsequent governing body or not? What does that do? What is 2904 if your theory is correct? And if Olathe or Spring Hill would have complied and sought Attorney General approval, what is the effect of that? Is that a perpetual agreement or not? What do we have there?
Well, I feel compelled to say, Your Honor, that that's not this case. However,
I understand.
Yeah.
But it could be the case. So
it could be at some point in the future. I would simply say this, Your Honor, the way I read Jayhawk Racing, and if the entire agreement is on a governmental / legislative issue like this one, and perhaps there's a way to write it so that it wouldn't be, but I must be honest, it does not occur to me as I sit here how that would work. I don't believe that Attorney General approval would get either city around the ultra vires doctrine, which is articulated in Jayhawk Racing or any of the long line of cases leading up to Jayhawk Racing. Again, you're asking me a little bit of a hypothetical, but that's how I would analyze it if I were in your seat.
Counsel, can you remind me what the relief sought was in this act?
Yes, declaratory relief, I believe, in count 1, injunction in count 2, and I believe count 3 was mandamus, which was to, I believe, if I'm recalling it right, asking either the city council or the city administrator to administrate the contract the way it was written.
Yeah, so it was specific performance, right?
That's how I read
it. Contract 101 lingo. They wanted the contract performed.
Yes.
So this again is not this case, but it might have ramifications in the future, and it goes perhaps to some of Justice Rosen's, at least the concerns implicit in his question. In your view, would there be an action even under Jayhawk Racing for some kind of a monetary damages claim or a detrimental reliance type of claim, even if the contract is not enforceable under principles of specific performance? In other words, Olathe may say, look, yeah, maybe we can't bind Spring Hill's future commission, but we relied on this explicitly to spend all this money or do whatever we did. And that's, we should have a claim to recoup that.
Yeah, I don't think so, Your Honor. If it's not binding on the subsequent city council, it's not binding either by way of injunction or by way of damages. It's simply not binding in my view.
Well, theoretically, the damages would flow from the prior Spring Hills city council's decision to enter into the contract. And I realize we're in hypothetical land. I'm just kind of exploring the question.
I don't think so, Your Honor.
Okay.
I don't think so. To me, that would be akin to saying that, a contract which was entered into beyond any contracting party's authority to do so could somehow be subsequently enforced because that person didn't have the authority to do it. Now, with respect to reliance, I know there's been a lot of discussion of reliance. I simply want to remind the court, since that was part of your hypothetical, that there has been no finding of reliance in this case. And that's part of the reason that I recited the language of the attorney for Olathe going in, is that not only is there no finding of reliance, I don't think there's any basis to find reliance, or that reliance in this situation could be reasonable in any event. I know that's a little beyond the answer to your question, but since we touched a little bit on reliance, I thought I should get that out.
Counsel, can I jump in and ask if 122908 is ambiguous in terms of government service activity or undertaking, what can we glean from the legislative record or testimony? And can you give me your kind of interpretation of that legislative history?
Sure. I've got that in my notes here, and I'm going to turn to it if I can find it. But essentially, 122908, the legislative history, and I think this is set forth in my reply brief, it specifically mentions, quote, consolidation of services. And that refers to things such as fire, police, water, roads, sewer. And I think the intent is quite clear that what the legislature intended when 12-2908 was enacted was that two cities could agree, which they often do, for example, that one municipality will provide police service to both municipalities and simply get a paycheck from the one receiving services. For example, I've done a lot of work for school districts in the past, and they oftentimes simply enter a contract with the city that they reside in for the services of an SRO, a school resources officer, to simply provide policing in the schools. I think that's exactly what 12-2908 was intended to authorize. I do think, and I believe it was Justice Rosen's questioning, that the correct distinction to make here is that that's different than a contract which envisions no consolidation of services whatsoever. It does not envision a service contract. It's really nothing more than a restrictive covenant saying that you forever will not annex into this territory and I forever will not annex into that territory. So that's a long way of answering your question, Your Honor, by simply saying that I think the legislative history in this case supports the notion that 12-2908 does not apply to this annexation contract.
And I think that history does sort of, as I understood it, it's consistent with your explanation, which gives meaning, I think, to the government service language in the statute. But but they didn't stop there. They added activity and undertaking. And I didn't know if there's anything in the legislative history that would explain why go beyond government service then, if that's the sort of the targeted.
It's a little bit broader, isn't it? It seems a little bit broader than just services. And it does. It says services, activities, or undertaking. Nonetheless, I think the key language in 2908 is, quote, to perform. To perform, to me, is the operative language and the decisive language, not service, activity, or undertaking. It's, quote, to perform. This agreement envisions the performance of no activity, of no service, of no undertaking.
Well,
It envisions refraining from all those things.
Under Mr. Rupp's argument about this being an undertaking to do long-term planning, Isn't just the mere fact of entering into the agreement the performance of long-term planning? Does it have to be performance that continues through the duration of the contract, or can it be accomplished with the contract?
Well, I think that that is a question which is answered by the fact that this lawsuit is not filed to enforce the planning or the sort of joint planning. It's only to enforce the restrictive covenant. The parties may continue to plan together, but they simply cannot assume that this one annexation line that they drew will apply forever and ever at Olathe's choosing. I'm not sure if that's exactly answered your question, but I do not think that this is an agreement for joint planning. If you read the agreement, it's a restrictive covenants, and the reasons they give for wanting these restrictive covenants is because, yes, it will help them plan. I understand that, but this is not a contract where we agree to do any particular planning. This is a contract that is about a restrictive covenant, and then each individual municipality does their planning to the extent they can based on that agreement.
But does just the existence of the contract perform a measure of that long-term planning by saying this is the borderline? You have, just by signing that contract, you have made a long-term plan, and you performed a long-term plan by just setting that baseline?
And I think what you're trying to get me to respond to is, does that planning itself constitute a service activity or undertaking that would qualify under 12-2908? I think
and does it also accomplish your verb, your reliance on the verb of performing?
Okay, I see what you mean. I think not. I think not, because the planning is something that the parties do individually. It's not something that they bind each other to do. The only thing that the contract binds the two parties to do, and what this lawsuit is about the restrictive covenant. And that is an agreement not to perform an activity, service, or undertaking. The notion of planning is not something the parties are bound to do under the agreement, and frankly, not something that Olathe is intending to enforce in this agreement. So that's why I think it doesn't bring this contract under 12-2908.
Other questions? Anything you'd like to add to wrap up your argument?
Oh, I'm sorry. I'm having a little bit of a hard time on your microphone. You're a little bit.
I'm sorry. I'm having feedback today. I don't know what's going on. So. Yes.
I'll wrap up briefly. And it's nothing that I haven't said already, but I think number one, that the 2006 annexation agreement is not enforceable against the city council under this court's ruling in Jayhawk Racing and all the cases leading up to it. And number two, in addition, the annexation agreement fails for lack of Attorney General approval under 12-2904. That's why I think the district court's dismissal was correct and should be affirmed by this court.
Thank you. Mr. Rupp, you reserve 3 minutes.
Thank you. This is an agreement to perform. It is an agreement that allows each city to map out when it's going to have water, sewer, roads, streets, interstate exchanges, and there was specific evidence of that at the temporary injunction hearing. There is in evidence a build out plan that maps out what year there will be water and sewer in each part of the growth area. That is performance of a governmental undertaking, and that is what is contemplated while you have future growth areas, and the state's statutes that authorize comprehensive planning specifically allow comprehensive planning not only within the city limits, but in the growth area. This serves a valid public policy purpose, and this court has never bound city councils to specific concept of the undertaking just within the terms of the next city council. The Simmons rule, for example, even in cases that are not authorized by statute and are at common law, the Simmons rule, which has not been overruled by Jayhawk Racing, is not addressed in Jayhawk Racing, specifically allows the city council, when it serves a valid, good public policy purpose, to extend contracts beyond that. I do believe that in answer to questions several of you have asked, I would say that the language of 122908 is not limited to governmental services, but it involves broader terms that empower municipalities to contract with one another. These are not terms of limitation. And I think for those reasons, every interlocal agreement involves some combination of political decision, perhaps proprietary decision, and obviously the challenges of interpreting what is what in that area are difficult. But we're not asking this court to set aside Jayhawk Racing, because we believe that this case is entirely separate from the public-private contract involving municipal debt that was involved in Jayhawk Racing. This is a case that involves an agreement between two municipalities that meets all of the requisite requirements, signed city councils setting forth the reasons for it, and that it performs a government service undertaking or activity. And we believe that you would in effect be saying to cities that every interlocal agreement is at risk, and we don't believe that would be consistent with the legislative intent. So with that, we would ask that, and we would recognize also that both the district court, following its entry of the denial of the temporary injunction, did put in place a stay of its order because it recognized the novel and difficult questions here. And the Kansas Court of Appeals on its own, it adopted that, indicating that it felt that there were sufficient reasons for doing that. We would ask that the court reverse the dismissal of this case, remand for findings consistent, but also keep the stay order in place so that the district court could then have the opportunity to determine an appropriate remedy under the circumstances.
Any further questions? Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. The court will be in recess until 11/8.